Are you tired of hearing stories in Nigeria where parents die and leave their children here, and relatives and family members fight the children for properties belonging to the parents? Today we'll be talking about how to legally acquire properties for minors in Nigeria. Take note, for the purpose of land transactions, a minor is a person below the age of 21. Now we're going to start with the provisions of section 43 of the Constitution of the Federal Republic of Nigeria, which expressly states as follows: subject to the provisions of this constitution, every citizen of Nigeria shall have the right to both acquire and own immovable property anywhere in Nigeria. Now, if every citizen has a right to acquire and own immovable property in Nigeria, why can't a minor simply own an immovable property in Nigeria? The reason is because there is a principle called legal maturity, legal capacity, and legal ability. This principle of legal ability and legal capacity for the purpose of land transaction is encapsulated in Section 7 of the Land Use Act 1978. Section 7 of the Land Use Act 1978 expressly states as follows: it shall not be lawful for a governor to grant a statutory right of occupancy to a person below the age of 21 years. I will simplify that for us. That simply means that a person below the age of 21 years cannot apply for a certificate of occupancy, what is popularly termed C of O. The reason is simple. Minors, for the purpose of land transactions, people under the age of 21 years do not have full legal capacity and full legal ability to enter into binding contract. A simple example would be a person below the age of 18 going out to vote. They can vote, yes, but they do not have the legal ability to vote. So they cannot, in a sense. They have a right to vote, but because they have not reached an age of legal capacity and ability, minors are not allowed to vote. We are just opposing the two scenarios here. Believe it or not, this is good for public policy, public interest, so good for the protection of vulnerable individuals like minors. Now, how do we go about solving this problem and ensuring that minors in Nigeria can own immovable properties? There are exceptions to the fact that minors are not allowed to own immovable property in Nigeria. There are two major exceptions. The first exception is that by devolution by death. We'll explain that shortly. The second exception is that a minor can own immovable property in Nigeria through a guardian or a trustee. Now, what do I mean by devolution by death? Devolution by death simply means that where a statutory holder of land dies and via a will, the property devolves to the minor, a person under the age of 21 in this scenario here, the property will pass to the minor with the liabilities and obligations intact, and there will be no problem with the property passing to the minor by devolution by death. No guardian or trustee will be needed in this scenario, but an adult will be needed to properly manage the property till the child comes of age. Now let's talk about guardian or trustee for the purpose of buying a property for your child. The first thing we want to look at is that parents are the natural guardians of their children, but in a situation where there is an issue with that, you can formally appoint a trusted individual or a legal professional. Now, the first thing you want to do is to appoint the trustee via a deed. A deed is a legal document empowering the said trustee to act as a trustee on behalf of the child. Now, the trust deed must contain the child's beneficial interest, the trustee's powers, duties, and accounting obligation, meaning the trustee must account for all that he does or all that she does regarding that land. The next step is to formally acquire the statutory right of occupancy in the trustee's name as trustee on behalf of the child. Now, the trustee fulfills his or her responsibilities, pay necessary taxes, ground rents, manages the property, maintains the property, and make necessary reports as needed. Once the child reaches the age of maturity, for the purpose of land transactions, which is the age of 21, a deed is executed for the purpose of transferring full ownership to the child. It could either be a deed of gift or a deed of assignment. Now, there are benefits and risks that comes with having a trustee for your child. I'll go through the benefits and I'll go through the risks. So starting with the benefits, it keeps your child's interests secure and enables you to acquire a property for your child fully under the Land Use Act. Where you have full accountability with the trustee, the property is properly managed on behalf of the child. Like I said earlier, there are risks that comes with this. The first is, if the trust is not created formally via a deed of trust, it can be voided or it can be misused. Mismanagement and abuse by a trustee is possible, although legal actions can be taken to solve this issue. For one reason or the other, there could be delay in formally executing a deed of gift or a deed of transfer to the child when the child comes of age and becomes 21 years old. But of course, legal steps can be taken to resolve this issue.